Welcome to SCOTUScast, Class Certification, Stipulations, and Appellate Jurisdiction Edition. Thank you for tuning in. On March 21, 2017, the Supreme Court heard oral argument in Microsoft Corp v. Baker. Plaintiffs brought a class action lawsuit against Microsoft Corporation, alleging that, during gameplay on the Xbox 360 video game console, discs would come loose and get scratched by the internal components of the console, sustaining damage that then rendered them unplayable. The district court, deferring to an earlier denial of class certification entered by another district court dealing with a similar putative class, entered a stipulated dismissal and order striking class allegations. Despite the dismissal being the product of a stipulation, that is, an agreement by the parties, the U.S. Court of Appeals for the Ninth Circuit determined that the parties remained sufficiently adverse for the dismissal to constitute a final appealable order. The Ninth Circuit therefore concluded it had appellate jurisdiction over the case. Reaching the merits, that court held that the district court had abused its discretion and therefore reversed the stipulated dismissal and order striking class allegations and remanded the case. The question now before the Supreme Court is whether a federal court of appeals has jurisdiction to review an order denying class certification after the named plaintiffs voluntarily dismissed their claims with prejudice. To discuss the case, we have Cory L. who is Senior Litigation Counsel for the Washington Legal Foundation. As always, the Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker. And now, Mr. Andrews.
Microsoft v. Baker is one of those cases that only a lawyer could love, I think, because it deals with the very highly esoteric realm of federal appellate procedure. So at issue is whether an appellate court must review an interlocutory class certification order if the plaintiffs have voluntarily dismissed all of their claims with prejudice. Now, a little historical background may be helpful in framing the issues presented in this case, especially for those listeners who aren't sort of gurus in appellate procedure or class action appellate procedure for that matter. So class action plaintiffs have long sought the right to immediately appeal from orders denying class certification. And in the 1960s and 70s, some federal courts of appeals began allowing such an immediate right of appeal under the so-called death knell doctrine, which said if the plaintiffs could show that the denial of class certification, if left unreviewed, would end the lawsuit for all practical purposes, that they could seek an immediate appeal. So in other words, under the death knell doctrine, if plaintiffs could demonstrate that absent class certification, the value of their individual claims made it economically impractical to litigate them on their own, some federal appeals courts deemed the denial orders to be final orders under 28 U.S.C. 1291 and therefore appealable. So you can only appeal from a final order. But in 1978, in a case called Coopers and Librand versus Livesay, the United States Supreme Court unanimously rejected that practice. The court held that the death knell doctrine wasted judicial resources by encouraging inefficient, piecemeal appeals, and that it unfairly disadvantaged defendants who had no similar right to an appeal from orders granting class certification. And so following the court's unanimous holding in Livesay, Federal Rule of Appellate Procedure 23F was enacted, which gives both plaintiffs and defendants the ability to request an interlocutory appeal from a class certification order. But Rule 23F vests absolute discretion in the appeals court as to whether to grant such a review. And so many of the concerns raised first in Livesay and now embodied in Rule 23F are back before the court in Microsoft versus Baker. The case arises in the context of a putative class action against Microsoft. The class action complaint alleged that Microsoft's Xbox 360 was defectively designed because the game discs could become scratched if the game console was jostled too much. And although the named plaintiffs requested a nationwide class consisting of all owners of Xbox 360 consoles, discovery actually revealed that this was a problem reported by only 0.4% of all Xbox owners. On Microsoft's motion, the U.S. District Court for the Western District of Washington struck the plaintiff's class allegations from the complaint, having concluded that neither causation nor damages could be proven in one stroke by common evidence. The plaintiffs then petitioned under Rule 23F to the Ninth Circuit for interlocutory review, but the appeals court denied the petition, leaving the plaintiffs to pursue their individual claims on the merits in district court. But here's where things get interesting. Rather than pursue their individual claims to finality, the plaintiffs moved to voluntarily dismiss their entire case with prejudice, declaring their intent to appeal the district court's order striking the complaint's class allegations. Although Microsoft stipulated to the dismissal, it made clear its belief that plaintiffs would have absolutely no right to appeal the court's interlocutory order on striking class allegations once that dismissal was entered. The district court granted the dismissal with prejudice and reserved to all parties their arguments as to the propriety of any appeal. So on appeal, the Ninth Circuit exercises jurisdiction, and it reversed the district court's order striking the class allegations. And so the appeals court relied on its earlier panel decision in Berger v. Home Depot, where it reasoned that in the absence of a settlement, a stipulation that leads to a dismissal with prejudice does not destroy adversity in the judgment that's necessary to support an appeal of a class certification denial. And so for that reason, the Ninth Circuit said the plaintiff's voluntary dismissal tactic created a final judgment giving the appeals court jurisdiction to decide whether certification was properly denied. Then the Ninth Circuit went on to hold that the district court had abused its discretion when it struck the class allegation in the complaint. And it relied on a 2010 decision in which the court had concluded that it doesn't matter whether the defect alleged by plaintiffs may never manifest or if it manifests for different reasons for different users, because typicality under Rule 23 can be satisfied even under highly unique factual circumstances. But the panel ultimately expressed, quote, no opinion, end quote, on whether the plaintiff should prevail on a motion for class certification, but instead it remanded the case for further proceedings for the district court to determine the viability of plaintiff's proposed class once again. Now, the 3rd, 4th, 7th, 10th, and 11th circuits have all rejected this approach, and they hold unequivocally that a named plaintiff's dismissal with prejudice of her individual claims following an interlocutory adverse class certification order is not a final appealable order. So on the basis of that circuit split, the Supreme Court granted cert, and when it did so, it added a second question for the parties to address in their merits briefing, and that question was whether jurisdiction exists even under Article 3's case or controversy requirement, given that all the claims were voluntarily dismissed with prejudice. So on the merits, Microsoft advanced several arguments as to why the Ninth Circuit's view should be rejected. As Microsoft frames it, either plaintiff's voluntary dismissal lacks finality under 28 U.S.C. 1291 because the plaintiffs can resume litigating their claims without the benefit of any appellate decision relating to the merits of those claims, or the case is moot because the plaintiff's claims cannot under any circumstances spring back to life. They were forever extinguished when they were voluntarily dismissed with prejudice. So pick your poison, Microsoft is basically saying. As a preliminary matter, this case no longer presents a justiciable case or controversy because the plaintiffs voluntarily dismissed all of their claims with prejudice, rendering any appeal moot. Microsoft goes on to say neither party contends that the district court erred in entering its final judgment disposing of the action with prejudice. In fact, the plaintiff specifically requested it, and, well, Microsoft very wisely agreed to it. And as a result of that invited dismissal, or almost you might say that invited error, if you will, to which all parties stipulated, Article 3's adversity requirement is utterly lacking, and a live dispute between the parties no longer exists to support federal jurisdiction, appellate, or otherwise. But then Microsoft says even assuming if Article 3 is somehow satisfied, the panel's holding hits up against the court's decision in LiveSay, which again held that allowing a plaintiff to appeal a class certification denial immediately as of right, rather than from a final judgment after an adverse trial on the merits, violates Congress's longstanding policy against multiple piecemeal appeals. Those appeals are impermissible, Livesay explained, even when the denial of class certification tolls the death knell for the plaintiff's entire class, an entire case. And if that weren't enough, Microsoft points out that the panel's expansive reading of 28 U.S.C. 1291 is wholly inconsistent with the proper understanding of Federal Rule 23F, which again grants both plaintiffs and defendants the right to request an interlocutory review of class certification orders. But it provides the appeals courts with the absolute unreviewable discretion to deny that request. And so if the court were to actually adopt the reasoning of the Ninth Circuit, Rule 23F would be rendered a dead letter. Appeals courts would no longer be left with discretion. They would have these appeals foisted upon them. The plaintiff's response is that a final judgment is always a final decision, and that the case is over when there's nothing left for the district court to do. And that's the case here. The mere fact that the final judgment is manufactured doesn't mean it isn't final for purposes of appellate jurisdiction. Plaintiffs also argue that the real possibility of appellate reversal on appeal has no bearing on whether the case is final or not. Otherwise, no judgment would ever be final. And then the plaintiffs argue that their voluntary dismissal was somehow conditioned on their intention to appeal the case. So the court held oral argument yesterday, and Peter Strist argued the case for the plaintiffs, and the bottom line is that the justices clearly were not buying what he was selling. Almost to the person, they expressed great skepticism, very dubious that this voluntary dismissal tactic can accomplish what the plaintiffs want it to. Some interesting quotes from oral argument. Justice Kagan, this was to Microsoft's counsel, Jeff Fisher. She said, "It does seem to me like you have an awfully good argument. Why did people in the Ninth Circuit think that this was the governing law?" She seemed almost incredulous that this was a practice that someone thought was an appropriate practice. Justice Sotomayor said, "I haven't been able to imagine a situation in which a case is dismissed with prejudice, but where there may be some issues that should survive." Justice Breyer, who I think clearly thought this was nonsense, said, "You're in a dilemma," to the counsel for plaintiffs. "If you say I condition my dismissal upon my late appealing, you run into our case law, which says that the judgment is final. But if you haven't reserved something, then you're in the box you're in right now, and the case is over." And I think it's clear that many of the justices think the box that the plaintiffs are in right now is one of mootness, where the case is over. Justice Ginsburg, for her part, went on to explain that the rulemakers went through a lot of trouble to figure out what to do with an interlocutory ruling on class actions, and it came up with Rule 23F, which is you litigate those individual claims to finality. This device, she says, seems to be just a way to get around Rule 23F. And Chief Justice Roberts perhaps put it, not too fine a point on it, when he said, "The reversal you're looking for doesn't go to the merits of the judgment that you asked for. Nothing that you're arguing on appeal is going to change the fact that you lose." And so, whereas a lot of Supreme Court arguments, leave one to wonder about the outcome, I think this one, the outcome is pretty fairly predictable, pretty fairly certain. Justice Sotomayor, for her part, did seem interested in trying to think of a more, as she put it, a more flexible rule. She said she doesn't like bright line finalities, and she was interested in looking into a Second Circuit case that held something similar to what the Ninth Circuit's rule is, to see some of the reasoning behind it there. But even she seemed highly dubious of the plaintiff's case. And so I'd be surprised if, with all the usual disclaimers that we don't know and that oral argument doesn't really isn't a good indicator, I would be surprised if Microsoft doesn't prevail in this case. and that's what I expect to happen when the court issues its opinion later on this term.
Thank you for listening to this episode of SCOTUScast. For more episodes of SCOTUScast, as well as audio and video of past Federalist Society events, please visit our website at www.fedsoc.org/multimedia.